Thank you to the Maryland Law School and to the Law Review. This is a really exciting event, and it's sort of a little bit outside my usual, the cast of characters that I usually run into, so it's been really fun to meet a bunch of you. I'm really grateful for the hospitality, and I have to say I'm a little bit sheepish about coming here today. Because the wonderful Danielle Citron will be joining us at BU Law next year, for those of you who have not heard. But I just want to convey to those of you who are part of the Maryland community just how anguished she really is. It's not an act about leaving all of you. And as someone who has, over the last year, become a dear friend of hers and someone who cares a lot about her. I'm grateful to all of you for nurturing her and taking care of her and helping to shape her into the incredible scholar and human being that she is. So thank you all, and I'm really sorry. Okay, so this panel is a lot of things, right? IP, platforms, and speech. So we could cover a lot of ground, and I'm sure we will collectively. My focus in my scholarship is, a lot of it is on intellectual property and platforms, particularly copyright and trademark law and intermediaries, and how the law has responded to the digital revolution and various stages of the internet revolution. And in listening to this conversation, I've had a variety of different intellectual and emotional responses, the first of which is, oh my God, I am so old. Like, I can't even tell you. I was here. Like, the very first conference I presented at when I was a baby law professor was about Napster. I mean, honest to God, right? That's the first thing that I ever wrote, was this little essay about Napster. And it is so interesting for me to feel like this conversation has come so full circle. Hearing Woody talk about this being sort of the golden opportunity of a moment to talk about possibly regulating tools and making platforms think responsibly about the costs, right, of the tools that they are developing, is a really interesting thing, because people were saying this at that time, but it was all the intellectual property rights holders that were saying this, that were making this case. And we as academics, or the other academics in the room, were very skeptical. So I have always been a believer that we need sort of mediation, and we need to think about responsibility. We need to think about when people develop tools that can be used for good or for evil, ways to help to bring out the best in them so that they can realize the good but minimize the threats, if possible. Right? In some circumstances, it may be possible. In some circumstances, it may not. But so I feel like, you know, suddenly I'm surrounded by all these people who believe that. When, as a baby law professor, I was sitting there facing Pam Samuelson, who was saying, hands off technology. And I was like, ah! You know, it was really scary for me. No, and I think there are really good arguments. She's wonderful, and there are wonderful arguments to be asserted on that side. But the point is, the Academy spoke with a single voice, practically a single voice at that time, and that was that voice. And I felt very lonely, sort of, you know, saying but, and so it's just interesting for me. It was really sort of heresy. The kind of arguments that Woody was making today would have been heresy at that time. And I think it's true that the reason we are able to assert them those arguments now is because real people are being harmed, right? We are sort of these stories that you all are telling and that Danielle has so effectively told in her, in much of her work, are compelling human stories. It's not just some evil corporation who's losing money, right? And so that does change the nature of the debate and adds nuance to it. So I come to this conversation from this perspective, from the perspective of intellectual property law. And as I was thinking about what I might say to you today generally, I thought I would divide my substantive comments into two sets of thoughts. They're really sort of disconnected from one another, but they're two ways in which I think intellectual property and/or the experience of intellectual property law as applied to platforms may have something to say about the debate that we're having, or the conversation we're having here today. All right, so the first sort of cluster of thoughts has to do with the notion of fakes. So trademark law, which is where I spend a lot of my time, is all about fakes, right? At least in its original genesis, trademark law existed exclusively in order to prevent people from passing off their products as having been sold by someone else with a good name, right? Passing off. So this notion of, in the trademark context, it's typically sort of the marketplace, the economic marketplace, being infected by this false information, and consumers of products being duped, and trademark holders who had good reputations being harmed as a result of that deception. That's the foundation for trademark law, right? So when we talk about sort of deep fakes as applied to human beings, as a trademark specialist, you know, one of the things I sort of play with in my mind is, so what does trademark law have to say about this, or what does this have to say about trademark law? And I'm not sure it has anything to say other than the fact that they both deal in fakes. But there were a few ways in which I think there may be some relevance of trademark law. The first is in the conversation that we had earlier today about parody and about the difference between situations where a fake results in the audience perception that this is the real person doing this thing, right, on the one hand, and situations where we can perceive this to be a commentary on someone, a parody of someone, or some other third party speaking through this person's physical being on the other. So the difference between sort of holding yourself at that the creator of the image, making the audience believe that it's actually the person depicted in the image who stands behind the image and is doing the act that is depicted in the image. That strikes me as causing a particular type of harm that is distinct from the type of harm that occurs when the audience knows, right, that some third party is using someone's image in a way that is intended either to comment or to harm, right? And that distinction, that there can be harms in both cases, but they're sort of different types of harms, right? And they're different types of harms in I hate to say in the same way, but in a similar way, that you have a different type of harm when someone parodies a trademark holder or criticizes a trademark holder or says this to a trademark holder, right, than you do when someone holds themselves out under the trademark as offering a product or service under that mark. In a way that affects the trademark holder's reputation because people associate this bad actor, right, or this bad act, with the trademark holder, and assume that it came from the trademark holder. Trademark holder distinguishes parody and critical commentary about trademark holders from other uses, confusing uses of marks. Typically, if the observer recognizes the parody, and Jess points out that sometimes it's very difficult to make that distinction, but if the observer recognizes that this is someone speaking about the trademark holder, rather than someone who is the trademark holder, trademark law is more, gives more deference to the speaker, right? The exception is in sex cases. And so this is sort of an interesting idea that might give us something to talk about. Like, you know, maybe deepfakes aren't so harmful if you can perceive the difference between the speaker and the object of this speech, except maybe there's something special about sex cases. Trademark law actually treats sex cases differently. I'm not sure I agree with the fact that it does, but as a matter of fact, the trademark anti-dilution statutes have been interpreted in a way that even if you are clearly different from the trademark holder, if you use the trademark in ways that have to do with sex, then you're bad, right? And you can be found to have violated the dilution laws. So that's sort of an interesting parallel that might have some relevance, at least peripherally in the trademark context. I always think that I'm going to have way too little content, and then, you know, there's no way I'll use all my time. But so in the interest of time, let me move on to my second theme, which has to do with the experience with regulating platforms in intellectual property law as distinguished from the areas of law that we're talking about here today, because I think, right of publicity aside, this really is more of a kind of harm to person issue than it is an intellectual property issue. So for those of you not familiar with the experience with platforms, Section 230 of the Communications Decency Act, which we heard about earlier today, exempts intermediaries from liability for harms that result from third-party use of their platform, unless it's an intellectual property case. Why do you think that happened? It's really a political economy story, right? In the context of intellectual property law, we had Disney, Microsoft, we had all of these content industries who were recognizing the effects that the internet would have on them, the negative effects that the internet could have on them. And they, armed with their lobbyists, came to Washington and said, well, first they sued, right? But ultimately they came to Washington and said, look, we need some kind of protection. We need you, Congress, to force these intermediaries to act responsibly, right? To act reasonably, to respond to the proliferation of trademark and copyright infringement, actually just copyright infringement that's happening on this network. And so there's a very long story, which I'd be happy to talk about during the break, about how the courts and Congress responded to this. But basically, we have a situation where intermediaries, when they receive notification of infringement, in the copyright context as a matter of statutory law, in the trademark context as a matter of common law, if it looks like it's bad stuff, they're supposed to take it down. They have a legal obligation when they receive a notification of infringement to act by removing the material from their network. That doesn't occur in this context, right? Section 230 of the CDA protects the platforms in the non-IP context, right? So we have a model in the IP context for at least some semblance of sort of reasonable behavior, responsible behavior by intermediaries. At the same time, it's very difficult in some of these cases to make the determination of what is or is not a violation of someone's rights. And that's true here too, right? There are many circumstances in which a parodic deep fake might be really, really funny, not involve sex, and none of us would want to take it down, right? So how do we draw the line between the good stuff and the bad stuff, and how do we require intermediaries and more likely the minions that they have sort of looking at these notifications? How do we think about their obligations to sort of look at this notice and determine whether it is in fact lawful or unlawful? It's a really tricky question in IP law, and we've sort of reached a point where there's a zone of reasonableness around intermediaries' behavior. That's why we have things like mashups of copyrighted works, right, which are protected by fair use, which are kept up, and all is well. Final point, and I know I probably am over time now. One of the concerns that I think Danielle and Bobby have identified in this piece, and Danielle has identified in her other work, is the concern about truly bad actor intermediaries, right? So there are the intermediaries that are kind of trying to act responsibly, and we want to protect them within a zone of reasonableness, right? But the people who set up their sites specifically to distribute content that is harmful in the ways that we're talking about today, right? Should we have tools to target those people and not to give them that same sort of presumptive zone of reasonableness? And here, too, intellectual property law offers us the promise of some tools, though, again, they're imperfect. But both copyright and trademark law have a doctrine of inducement that is available against intermediaries who the facts demonstrate suggest are intending to enable other people to use their platforms for ill, right? And I'm sort of critical about those doctrines, but they are kind of an interesting parallel here that would allow us to say, okay, if you're basically a legitimate platform that is used sometimes for bad things, we want you to act responsibly, but we're going to give you some flexibility. But if you're really, really here just to enable harmful behavior, then maybe we should find tools to go after you. So thank you, and sorry for going over. Thanks.
Okay, here we go. All right. Yeah. A little bit of presentation minimalism as well. Well, first of all, thank you so much to Danielle for having me here, and the University of Maryland Law Review. I'm delighted that I'm going to be publishing my paper, Drawing Trump Naked, with you guys. So that's what I'm going to talk about a little bit today. I'm sorry for the image that this will put in your head, and even sorrier when I actually show you the image later. So just get it over with. Yeah, no, I'm not going to. So I want to start with this, which is a tweet that I put the other day. Sorry to call you out. So Kate was getting all excited about the fact that we were going to be talking about deepfakes at this conference, and I felt compelled to put this out there to the world, which is that a year ago we were sitting in a bar in New Haven, and she said this to me. I don't think you need to worry about the issue of deepfakes. And I mean, this is really my response now. It is true that nothing has sort of shaken my convictions in like what I think the First Amendment, should do or should be about than the issue of deepfakes. And really, my paper that I've written, Drawing Trump Naked, is kind of the result of years worth of struggling with how can I keep to what I think the First Amendment is about and should be about, and yet also grapple with the harm that I think deepfakes can create. And so I think you'll start to kind of see that in the way that I talk about how the right of publicity, I think, could maybe provide some sort of way to redress some of the harms by deepfakes. So I'm going to start with this, which is very different from some of the other things we've been talking about today, which is a commercial advertisement, right? So when we think about the right of publicity, for those of you who don't know, is a state law tort. It's in now over 30 states, and it is the right to stop other people from using your name or your likeness or some other indication of your identity without your permission. So by its very terms, we might actually think this is the perfect thing to get at something like a deepfake. You're using somebody's image in a way that they don't authorize, and there's some sort of harm that flows from that. But the issue, of course, that I'm sure some of you can already sense coming, given that this is a panel about free speech, is that the very terms of the right of publicity really would cover so much speech that we all know and feel should be protected just by its own terms. So this is really the story of the right of publicity. It's an exercise in trying to figure out how can we put some boundaries on what otherwise is really just going to cover huge swaths of otherwise protected speech. And so the way that I like to think about this is that the right of publicity has a commercial core. By that I don't mean that it only applies to commercial speech. There are some people out there who think that it should only apply in the commercial context. I don't think that, and I'd recommend Jennifer Rothman's wonderful work on the right of publicity for anyone who wants some of the background for why it shouldn't just be seen as commercial speech. But I do think that the story about the commerciality is really important in understanding the way in which torts like the right of publicity interact with something like the First Amendment. So this is an ad that Michael Jordan sued over because a supermarket chain wanted to sort of offer this commemorative ad to celebrate his many achievements as a great basketball player in Chicago. And he sued. He really didn't like that, even though Michael Jordan himself, his image isn't here. It's very clearly evoking him, and it says there's the congratulations, Michael Jordan. His name is used. His famous sort of number 23 shoes are there. And he won this case. And one of the reasons why the court felt like there was no First Amendment defense that the supermarkets could raise here was because this is clearly commercial speech. And that has a very special connotation in constitutional law. And the boundaries are a little fuzzy, but the way that it's generally sort of helpful to think about it is it's definitely a commercial sort of ad or some sort of proposal for a sale of a good or service. That's quintessential commercial speech. There are things around the edges that make it a little more complicated than that, but when it comes to the right of publicity, it's helpful to think as this being a fairly textbook case of something that you can have a right of publicity claim, and the First Amendment probably isn't going to stand in your way. But what I look at in my paper is the far more, I think, interesting and complicated question of how does it interact not with commercial speech, but with expressive works. And by that I mean everything from movies to books to art, and all of the sort of ways. It's really a sociological question. It's what are the sort of mediums that we use as a society in order to sort of convey ideas and opinions. And so this is kind of a category of speech that the Supreme Court, at least sometimes, has reached for as a category that deserves sort of heightened First Amendment protection. And so you might be wondering, what does this really have to do with deepfakes? Well, there are a number of ways, it turns out, that courts have tried to grapple with the fact that people are portrayed in expressive works against their will, and then they sue. And of course, one of the first things that the defendants will do is say, no, this is protected by the First Amendment. One way that could be relevant to deepfakes is that a lot of states now have passed sort of statutory exemptions to the right of publicity that just say, if it's used in an expressive work, or if it's used in a movie, a book, whatever else, then the right of publicity doesn't apply. Just blanket exception for anything that constitutes an expressive work. Another way is this so-called Rogers test, and that relates back to some of the things that Stacey was talking about in terms of analogies to trademark. We're looking at whether there's some sort of false impression created by the expressive work, that there has been some sort of endorsement there. And then a third way that some courts are looking at it is they're applying the constitutional idea of strict scrutiny. So is there some sort of compelling interest that gets served, and is the law narrowly tailored? So these are all tools that courts and legislatures are using to try and bring the First Amendment into play. I don't have time to go into all of the details, but in my paper I talk about why I think none of these are a good way to go about it, and the sort of Cliff Notes version of why is deepfakes. That's why it kind of comes back to this. All of those types of responses, these sort of free speech, First Amendment responses, blanket exceptions, strict scrutiny, and this kind of false endorsement type idea. None of them are responsive to the type of harm and the type of interest that we might think that states might reasonably have to combat deepfakes. If it's a blanket exception, I think a lot of these deepfakes are in some form sort of short movies. So if we're going to treat them as expressive works, which I think it's likely a court would do, then that would just be out of the window. You wouldn't be able to bring a right of publicity claim. I think that that's a problem. If it's a question of creating some sort of false endorsement, often, would we think that the harm is any less just because there's a disclaimer at the front of the deepfake video that says this is actually a fake? No, I think the person who's portrayed in it would still suffer some sort of harm. As Stacey said, it may be a different type of harm than if you are actually tricked into thinking it's true, but it's still nonetheless a harm that we might think that there should be a remedy for. And then similarly, sort of strict scrutiny, the problem with strict scrutiny is that it doesn't really tell us anything about what we're supposed to find compelling in this arena. It just says a compelling interest, but it's not really responsive to what the ideals are for why we might protect expressive works. And so I'm just going to, in the interest of time, sort of go through a few other things that we might sort of think about in this area. This is the human cannonball zucchini, which is the only right of publicity case to make it to the Supreme Court. It's not terribly relevant here, so I'm not going to dwell on it, but my sense is that one way in which you might have to take the First Amendment sort of into account when it comes to right of publicity is if you are totally depriving somebody of an incentive to do what it is that they do to make money. This is like one area where we know that the court thinks you can have a right of publicity claim and it's not going to be blocked by the First Amendment. But then, and this is going back to Marianne's talk earlier, this is the Campari ad, right? So the reason why the Campari ad is so important in this kind of doctrinal question that we're grappling with is that, as Marianne talked about, the court was not, the court did not deny the fact that this was really harmful to Jerry Falwell. It wasn't a case of them saying, we just don't buy the fact that he's hurt by this. But what the court did do, which I think is really important to understanding sort of deepfakes, is to say, in the realm of public discourse, in the realm of things that are sort of put out there in these kind of mediums through which we sort of form public opinion, sort of grave emotional harm sort of to dignity, you really can't regulate based on that. And that is something that I think any right of publicity claim that is going to go after a deepfake really needs to kind of grapple with. Then we have this. I am sorry for it. And now I'm going to move right past it. But I'm sorry, but that is the image that inspired the paper that I wrote. The artist who drew that image was in fact threatened by Trump's legal team for portraying him against his will.
And by everyone with
Yes, exactly. So I'm sorry, but it is important that you visualize these things to understand the stakes. And then finally is the NCAA video game, which is also a famous right of publicity case. So I want to save time for questions, but I guess I'd just leave it with a thought that we need some way to be able to parse these different types of uses of people's images in a way that just that actually makes sense within the doctrinal framework that we have. And it's really difficult to do when you accept, if you accept, as I think the court is sort of likely to do, at least for the foreseeable future, until Justice Marianne Franks gets on the court and changes everything around. But you know, that these types of mediums do get special, or at least get full First Amendment protection. This kind of medium-based protection that we see is just going to be a really difficult thing for anyone wanting to bring a right of publicity claim against deepfakes to grapple with. But I would encourage people to think about the ways in which you can make arguments that actually sound in free speech values as a way to sort of say, even though this is used in an expressive work, you know that there is actually a First Amendment interest in allowing some sort of regulation here. So one thing that sprang to mind when we were talking earlier is this idea of, you know, this violation of autonomy. Well, there are doctrines like compelled speech. We can start sort of thinking creatively about reforming the doctrine to allow something like, when you are portrayed in such a vivid and visceral way doing something that you didn't do, is that some sort of compelled speech that the law might be able to recognize? Another way to think about it is the values that underlie why we protect something like an expressive work, to my mind, comes back to the idea of sort of the legitimating function of free speech. We, as a society, we protect all sorts of speech that we recognize is harmful, but we do so on the basis that in the realm of public opinion, in the realm of this thing that we talk about of public discourse, we need to be free to sort of say not whatever we want, but a lot of what we want, in part because we think that that's the only way that we can kind of believe in sort of self-governance, right? This goes back to why we might have free speech in the first place, is to feel like government is responsive to us. Well, if speech sort of violates civility norms to such an extreme degree that legitimating function is in fact undermined, then we might think that it's not serving the underlying value that free speech is supposed to further. This is this idea that somebody who I work with at Yale, Robert Post, has talked about a little bit. This is the paradox of public discourse. Can public discourse become so extremely uncivil that it actually undermines the very purposes for which you have free speech? I think that there's room there to work on. So it's not a terribly optimistic story for how likely it is in the courts to succeed, but I think we need to think about ways in which you can use free speech type arguments to actually allow for greater restrictions on some of these expressive works. I think that that's the way that we might resonate with judges who would otherwise want to just throw up their hands and say, this is an expressive work, the First Amendment kicks in there. So looking forward to your questions.
Thomas, I now regret that you went before me. But for one thing, I don't regret. I mean, you finish on a point that I would like to talk about, on this notion, this kind of small R Republican notion of civic virtue and civil discourse. And I think I'll talk a little bit about that. But I will channel what you started with, Stacey, and this is this idea of making sure that platforms behave responsibly, right? And that responsibility matters. The core question is, what role does law have to play in all of this? And I think it's easy to contest that law has any role, right? I mean, it's to the extent civil society in democracies operate, whether or not laws advanced certain ideas or not, is actually core to democratic life, or is arguably core. But I do want to take up a point that Danielle, you made earlier in the paper you talk about, and that is that for the operation of democracy, truth matters, and that while there could be a debate and discussion about what truth is, I think there can be no question for those of us, for many of us that think democracies matter, that truth is essential to the operation of democracy. And we can take up that question later on. I don't want to actually contest that. I don't want to have that to be the nature of the discussion. I'm making that strong assumption here. As it turns out, there is a practice in the United States and in many democracies that furthers this objective of truth, of seeking truth out, and that is journalism. So what I'm going to talk a little bit about, I think, is the journalistic practice of truth seeking, that is, a belief in the pursuit of finding truth. And verifiability and balance. Now, these are contested things that I'll say a little bit about as a historical matter, but that's what I'm going to be mining. And I'm going to be talking about this in the context of something I've written a lot about in the past year and a half, inspired by work that Marianne and Danielle have done in the context of Section 230, and Ben, of course, as well, more recently. So what I will try to do here is situate the practice of journalism, a journalistic practice, in the context of a doctrine that is extremely protective of the distribution of data and information by platforms. And I want to do two things. First is to assert that Section 230 doctrine removes any sense of obligation as to all content. And that's it. I want to be quite plain about that. There are opportunities for platforms to be responsible, but Section 230 removes the responsibility as a matter of law. That's a problem. Second, and we've heard a lot of that already. I'll say a word or two about that. Second, I'll take up this question of whether law has a role in engendering a sense of obligation. And there can be some disagreement about that. I want to talk a little bit about the regulation of, the history of the regulation of communications in this context. And then I want to actually draw on something that Danielle and Bobby recommend in their paper, and is a kind of conditional immunity, but actually invoking the journalistic practice, like the norms and conventions associated with journalism as the conditions for getting immunity. And we have stuff that does that already, and the reporter's privilege and journalism shield laws. And so this is at this point a half-baked project, but if I were to pursue this, this is the sort of idea that I would continue. When I say half-baked, it's not fully developed just yet. So Section 230, many of you have heard already about it, or a lot about it. Let me just, just so we're all on the same page. It basically sets out an uneven regulatory arrangement so that all communications platforms are subject to public law and other remedies under law, save for defamation or the distribution of discriminatory ads in housing markets. All other entities are subject to law except for interactive computer services. And the reason for this in 1996, there were several. One of them would be a remarkable imposition and burden on providers to have to handle all the content that passes through their platforms to be able to impose liability on them. This would further free speech values, right? We would enable all kinds of content we disagree with, ugly content, and this is consistent with a strong view of what democracies allow, and that there will be a market for moderation, that there would be an incentive to moderate content, but that courts and public law shouldn't decide what that is, right? That the market would sort that out, and we wouldn't, and that the market is as good a regulator of speech as governments are, if not better. So to make it plain again, public law protections for consumers and other protected groups are dead letter under Section 230 as to the behavior of platforms or what platforms do. They do not have any legal obligation to moderate the information that they publish or distribute. It's a strong argument, and these are the strong arguments for it. There are real perils for such a sweeping protection. Danielle, Ben, Marianne, and I have written about what some of these problems include. I've written about how the extent to which many of these providers do far more than act as passive conduits or as thoroughfares of user content. They actually elicit, collect, sort, analyze, and repurpose data for their own bottom line. I think that has to complicate the story. It also, I don't want to say much more about it because I said it a year ago, but it's a disingenuous claim to purport to be passive or to be just a conduit insofar as that there are serious benefits that were down to these organizations that are never experienced by the users themselves, right? Which is the logic, I think, supposed to be the logic of 230. This protection is erected mainly by judges, so it isn't just this statute. I actually read the statute as not doing as much work as many judges think. But judges since 1996, from 1997 to today, in the Ninth Circuit in particular, have been extremely generous in this conception, afraid of squelching innovation online, for the reasons I said. But along the way, a lot of people have been hurt. My critique has been that this is, and others in the room have argued out that the lack of protection actually might harm historically subordinated groups. And I don't want to repeat that. What I want to say is some people read this argument as being about choosing, as preferring certain kinds of protections under law over others. And I want to assert that that's not true. That the real problem with the broad reading of Section 230 is the evisceration of obligation across law, right? So it isn't just because there are civil rights violations that happen, it's because it actually corrodes the sense of civic obligation. And at a grand scale, this is bad for democracy, right? That's my claim here. And so there's no looming possibility of liability. There's no concern about developing or articulating an affirmative obligation as a matter of course. And there's too much evidence that's plain that underscores this. Enter journalism. So the journalism, sometimes when you hear people talk about it, it feels like an old technology. And we might assert that it is an old technology and the practice of journalism as being an old practice because it's associated with old media, like newspapers and the wires and broadcasting. But journalistic practice, to be clear, is not necessarily bound to those technologies. Indeed, if you allow that journalism is the professional practice of testifying about the truth of our shared life together, then there are still opportunities in 2019 to think about those values. And I would have platforms take up that responsibility. The question is how under law. I do want to say that, I don't know how many of you read The New Yorker. Jill Lepore has a New Yorker article that came out that says a lot of what I would want to say, but far better, and also has some very interesting, makes very notable, interesting points. But that on this point about journalism and its historical place in our democracy, one of the arguments she makes is that this contemporary commitment to engagement for platforms, right? What Facebook is most interested in is making sure they have a lot of clicks and eyeballs and attention. That is actually now corroding the journalistic practice of New York Times and the Washington Post. And so there's clearly a relationship then between all of these, the new and the old, and I think we have to double down on the norms associated with journalism. And so what I'll say here is, so do a little history on this because my time is running out. Objectivity and professionalism in journalism wasn't always obvious. In the 1830s, it was actually a practice that was associated with advocacy. And so the practice doesn't become committed to balance and verification and objectivity until the end of the 19th century with industrialization and the growth of massive newspapers. I'm not the one that discovers this. Media scholars have been writing about this for quite some time. So it becomes a commercial practice. And why is it a commercial practice? It's because they're heterogeneous audiences. You have to speak to many different people, and you want to make sure you get as many audiences as many people as possible, and advertisers want you to do that, so you flatten out the claim, right? You make sure you cover all sides. This political economy, I think, is quite interesting and important for thinking about the immunity under 230. We have a practice that has been in place. It is born by this political economy, but here comes the 1997 statute kind of out of nowhere, without any kind of political economy yet set, and the industry is at that point unable to begin thinking about how to attend to things like, or is blocked off from considering things like reaching broad audiences. Actually, it's quite complicated by the internet, right? Where the objective isn't to reach heterogeneous audiences, but to reach disaggregated ones. All right, so I'm going to skip ahead and talk about how to maybe operationalize all of this. I hinted at it at the outset. The drafters of the immunity were not thinking about the things that we are talking about today. And also, I want to acknowledge that the discussion of journalism is adjacent to the discussion of fake news. It's not directly on it, but I think it helps us sort out the question of how we implement a law that promotes truth and the obligation to make sure truth is attended to. What I would like to see, so just jumping ahead, I'd like Danielle and Bobby's argument for a reasonable standard of care in an amendment to Section 230. I would recommend that the immunity also be conditional, but that it cite to the norms associated with the practice of journalism, as in, well, we heard about digital provenance a second ago, but more than that, kind of institutional commitment to attending to finding out what the truth is, right? And that might be using state-of-the-art technology, but a kind of demonstrable indication that there are steps being taken to make sure that platforms are acting truly as what the title of the statute calls good Samaritans. We might worry if this imposes burdens on smaller intermediaries, which is often an argument that those of us who've argued for an amendment to Section 2 assert, and I'm not as worried about that insofar as all of these, as long as a platform can evince a commitment to the challenge of verification, of engaging in verification. And again, I don't think this is that hard to do. It's contested. I don't think it's that hard to do because there are journalism shield laws. There's a reporter's privilege. All of these draw on prevailing conventions and norms in law, and courts have to resolve on whether or not an entity is a journalist or not, or whether a reporter is a journalist or not, to be entitled to protection. So I have much more to say about it. I've kind of rushed through this. I look forward to questions after.
All right. I think that these are kind of actually really well arranged because I'm kind of responding to everything that Olivier said and kind of to speak to a different type of point, but I'm kind of going to talk a little bit about norm setting, but not kind of from a journalistic standpoint, but just kind of as a like a demos or as like a populace globally. I kind of want to take a step back because one of the things that people were talking about so much in the morning, and I kept waiting for someone to do it, but it never kind of got brought up, which is kind of like, this is just so different. This is something that is so different, and this is so bad. Like, this hits us in some ways being really bad. And people are like, why? Why is this so much different and worse than everything else that we've, like, fake videos or fake editing or whatever else, or editing of other videos or impersonations or whatever else it is. And I really kind of want to drill it, put on, like, my background is in cognitive psychology, and I want to put on my cognitive psychology hat for a second. And it occurred to me that this is also kind of very evidence law based, which is this idea that how do we determine if something is true or not? And we use our senses and then we reason from what we observe, right? At a very core level. And the reason that deepfakes are so concerning is the very easy answer of kind of just that we can no longer trust our senses and that no amount of reason will get us to a different answer because we've literally changed like the facts as they're presented. And the other piece the other kind of cognitive psychology piece of this is that there are kind of, this is kind of I was trying to find the study, but I couldn't find it, but I know that it was an early study of basically how people determine truth and what they put the most faith in and how deeply they believe something. And it's kind of a fidelity argument and an information argument. And it goes basically, the hierarchy is this, that things that you trust the most and you believe to be the most true are the things that you yourself have seen in person or lived and experienced. The second thing is video. And the third thing is photos. And the fourth thing is text, right? And so in this thing, we've all of a sudden jumped the Rubicon of like being in the ability to have something that is very, very close to a real lived experience and in video. And I think this is why kind of this is so incredibly unsettling. And this is something, by the way, that like is kind of reflected in evidence law, which is also your ability to kind of respond to this. So like this is why we have like in-person testimony is so important versus video testimony versus in the various kind of how you set up a case is that's kind of how that's how any like litigator would tell you is like the chain of kind of the validity of evidence or the verifiability of evidence. So the second thing that I kind of wanted to bring up is this is not the only thing. The fact that this is tricking our senses obviously is not the only thing. But you also have to kind of couple this with the fact that, of course, this is happening on the internet in this way that has completely, as Marianne has written about and Danielle has written about and Dina Boyd writes about, like kind of the four kind of ways in which the internet transforms how we spread information and how we spread speech, which is kind of, it's cheap, it's anonymous, it's infinite, it's instant, it's global, and so you have this complete loss of friction across all of these traditional ways. And so this is to kind of bring it all back to Danielle's first point about we need truth for democracy. This is why this is so damaging. It's truth and democracy are both completely challenged by deepfakes. That's kind of, those two ideas put together are kind of what is so disturbing. So how best to address this? And I am the worst law professor because I don't really believe in the law, and I'm just like, everything's norms. It's just norms all the way down. But that's a little bit of an overstatement. And that was also, by the way, Thomas's Thomas's tweet, that was a deep fake. That was not me. Don't believe everything you see, people. So basically, I'm gonna, and this is my point is very short, is that to kind of double down on what Olivier was saying, I'm going to kind of make the pitch for not solving this with law, in part because I just do not think we are completely aware of where this technology is going to go and the social meaning it's going to have. And I think that this is generally true, and I think that I always tell my students that when I was first on Facebook in 2004, that there was this norm, there was still a norm against taking a picture of yourself. It was seen as very sad, I guess, is like to take a picture of yourself, to take a selfie. And of course, this has completely changed. But in 2004, when I was like on Facebook for the first time, I remember there was one girl in our college class that like had a selfie. And everyone, I remember, like pulled up her page and was like, oh my gosh, can you believe that she took this? It looks like she took this picture herself. I think that she doesn't she have friends to take a picture of her for her? Of course, this has changed. This is no longer, but I mean, my point is how rapidly all of the social meaning of these various technologies have just morphed across time, and the social meaning of these technologies and how we're using them. So I am so hesitant to have a law, to pass a law, to interpret laws in some ways outside of the really bad actors that kind of Danielle and Bobby have written about, and Ben and Danielle have written about, that kind of deal with this. I do think that I actually was also, to Thomas's point and to Marianne's point, I actually looked at the identity protection theft. I looked at the statutes. They're all economic speech, so it is all economics. So this is like, it all like comes back to like all of these things are hinge in economics, and so that makes this very difficult to get at as kind of a dignitary harm idea. So kind of to wrap up, I was just going to say that I wanted to reiterate really a lot of what Jessica and Woody said in their talk, and which was kind of this idea that I think that kind of the future of this, before we do any type of regulations, we really do have to let the norm settle in this area a little bit. And even though it's an uncomfortable period for a lot of people. And so the situate, recontextualize, and re-narrativize is such a great idea. The education idea is so great. To bring this kind of back to fake news and the similarities to fake news, I think that after the 2016 election, fake news was all everyone was talking about, and everyone was having all these kind of like workshops and meetings about fake news. And I think that we have actually we didn't pass any legislation in reaction to fake news, at least not that I'm aware of. There was the Honest Ads Act, but that didn't go anywhere. And some of that, can get at commercial speech or advertising. But what was fascinating about that is that I actually think that kind of the fervor around fake news in the press and some of the attempts at regulation actually kind of created this norm shift in which people were all of a sudden aware that everything that they were seeing and looking at online and the articles they were reading and whatever else might not be true. And no one wanted to be an idiot. No one wanted to be that one that shared something that was fake news on their feed, or be the one that like posted it on somebody else's wall. And so you saw people calling each other out on Facebook or on Twitter for using fake news. And so there's this fascinating shift. And now we're not talking about fake news as much. I don't know if that's just because of just not because of the election, or whether there's actually been a change and it's not as harmful as it initially was, or we think that it's not as harmful as it initially was. So I'm just gonna kind of leave it there. And yeah, I look forward to your questions.
So, well, I was going to invite the panelists to interact with each other, but since we have all these busy little bees in the front row with their hands up.
Can I just add one thing to just on that last point, because it's directly, I think, in response to that. So I think there's an experience in trademark law also that relates to this kind of, if we let things settle down a little bit, people will adjust their expectations and get used to a little bit of noise. In the early days of the internet, courts were intuitively drawn to this idea that anytime someone used someone else's trademark, in an unauthorized way, they were by definition going to create confusion, right? They were going to divert customers and they were going to harm the public. And over time, the courts became educated to the idea that actually there are legitimate reasons that people might want to do this. And part of the argument that was given in support of allowing these kinds of uses was, look, if we prevent these kinds of uses, then yeah, people will get confused when someone uses a trademark in an unauthorized way, always. But if we allow them and we allow the norms to develop and consumer expectations to expect that sometimes people will use trademarks to call attention to some competing or comparative product, then consumers will benefit, right? And so there is something to the idea of kind of waiting for expectations to settle before sort of jumping on restricting speech and restricting behavior in ways that might have unanticipated costs.
I ask a question of both Olivier and Kate about I'm so taken by the statement you said, which I agree with, that law has a role in gendering obligation. And what I want to ask you is, what other forms of regulation beyond maybe technology regulation, but thinking more about the regulation of employment or labor, would help build obligation to truth, for example, in journalism or something like that, that we could push on? And right here, I'm just thinking about freelancers versus staff members have very different relationships to fact-checking, for example. And the more and more we are an economy of freelancers, that maybe the erosion of certain norms of the profession is fast happening. So I'm just wondering if there are other areas where law can promote the obligation that you're talking about. And Kate, the same question to you in terms of the norms. We're talking about the tech industry, and of course you've written about these new governors. How do those norms, how do companies start, where does the obligation within the companies come from? How do those norms, if you could say something more about the development of those obligations within.
Do you want to go first, Olivia?
You want to go ahead?
Yeah, well, whichever.
Go ahead.
Okay, so I don't know if this is on, so to the question about where those norms come from, I think they come from, at least so far, they have come from in kind of the immunity space because of Section 230, so they haven't had this kind of, they haven't had law to engender obligations, as Olivier kind of pointed out, which was, yeah, it was a nice, I really like that turn of phrase too. But there has been, slowly over time, there's civil society, and then there's, slowly over time, you've really seen they stake their entire business on reputation and users. So if you do things and have policies that are antithetical to the values of your users or hurt your users in some way, then you run the risk of your users leaving. So they will privately regulate themselves in order to try to match those like user expectations and preserve reputation. And it is soft power. You know, it's like a soft way to kind of have a voice. But in the absence of anything else, I think that's kind of how it works.
Jessica, I like the question. It looks like you have one answer, right? In the context of finding other ways under public law to encourage engender responsibility. I think you're invoking maybe labor law and unions, protection of collective bargaining, et cetera, which made me think, which is a point others have made and I've made, and that is I associate the immunity under Section 230 with a heavy deregulatory kind of small government approach to the world, and so I associate that worldview, and we surely have disagreement about this in the room, with a view of eviscerating the public space of public regulation, so which I think engenders, a sense of responsibility. When the Stacey, you started and you said you felt like a heretic way back when you were not as worried about public law intervention whatever, 18 years ago. Yeah, right. But welcome, because I'm not inclined to be as allergic to regulation for a variety of reasons, but I do think it's because it's healthy to think about how we share our resources and infrastructure together.
Thank you for this conversation. I'd like to push back a little bit on some of the conclusions that we made about the ability of let's just wait for things to settle down and see how norms shift, in the spirit of trying to make your argument a little stronger. Not because I agree with it, I completely disagree with it, but I think we can work together to strengthen both sides of our discussion. It was suggested that our lack of talking in the news about fake news suggests that norms are already shifting. People are calling out of each other as, oh, that's fake, don't post, or something like that. Let's set aside for the moment the sample set. So this is, I assume you were just talking about, anecdotal experience. But there might be other reasons why that's the case, even if we had an adequate sample. There are also, so first, the ability to discern, the ability to interrogate the information. There are, if we're looking at a particular type of network, let's say progressive network, progressives were far less likely to share fake news to begin with. It's far more likely that progressives, having shared it less, having succumbed to it less, are more able to identify it. Also, the second point is that I think, and Olivier made this point quite strongly, was that in the example of Section 230, Section 230 creates this expressive effect of lack of responsibility. Joe Toro at Annenberg at UPenn made similar findings about how the perception of lack of responsibility, or there's nothing we can do about our privacy, creates some resignation about it, and therefore diminishes social movements to create law to solve problems. I think that might also be what's happening with fake news. The less we allow law to deal with our problems, and the more we let norms given the existing legal status quo operate, the more resigned we're going to be to the fact that law can't do anything. So I worry about saying that it's a hard question, we should just let norms settle and trickle down to see what it is, and then create some law if there is. I worry about A, who's going to get hurt in the meantime, and B, where we're going to be later when we're already at a world where we've gone so long without thinking law can do anything. So I wonder if you have any way to diminish my nihilism or skepticism about that, about your idea.
Yeah, no, I was kind of speaking somewhat hyperbolically, kind of like I was not, I obviously don't think that laws don't have a place, and I do actually, and I just think that I don't imagine it as a trickle down thing. Like, I don't think that there should be a sense of we're going to know exactly and precisely how to legislate in this area, or we were not going to need to at all because a norm will evolve, or like a norm enforcement will evolve, or the problem will go away. But I do think that the entire internet is basically speech, obviously, and that there's that expressive role is hugely beneficial for most people, even though there are many harms that are also created from it. And so I guess that, like, my idea is that in a kind of a thinking fast and slow type of approach, that when you get really upset over a very kind of extreme and new and scary type of technology, that on the one hand, the really great point of, well, this is a great way to finally push us to make some better law about privacy generally, is like one great kind of takeaway from that. But the other takeaway is that, like, you run the risk of really bad laws that are kind of made in this moment of kind of panic and outrage, and that don't actually kind of take into account what we what actually bother us about it, or where the technology is going to go, or what it is. Maybe we're not even quite sure what it is that we're upset about yet. And so, I mean, some of it is, so that's kind of more or less what I was trying to kind of urge for, not kind of a total like norm, like let's not legislate at all. It's just kind of I just don't know exactly how this is going to settle down yet, and what deepfakes is going to have is to give us that might be positive, or like how much of a harm it will be.
Can I respond to this? I mean, I take Kate. I take your intervention as consistent with the view of what the 230 doctrine is about, right? It's this kind of government regulators, Congress can be very imprecise about what it is that something like deepfakes does to us. What's the mischief that that a statute would be after? But I think we can agree that, I mean, not just because Danielle and Bobby have written about it, although I'll follow anything Danielle in particular has written about. But I think we can agree that there's something about deepfakes that's unsettling and that there must be ways for us to solve the problem to the extent we can, right? And it is to say that we won't do anything, right? Is exactly that government and that the immunity is enough, that congressional intervention, regulatory intervention can't solve the problem is actually hamstrings us, right? We don't have all the tools otherwise available to us, the very tools we use for all other aspects of public life.
So this kind of gets to your point about, so this is, I said that it was about truth and democracy, but I think that another way of saying that is like, it's about verifiability and scale. Like, and so this is like really I think that when you say what's going on here, it's like I think that what you're proposing, why it's actually maybe what's really fascinating about what you're proposing is you're calling for like a return to journalism and journalism like norms as a way of doing verifiability at scale. Right, and that's but that's like a complete. That's not like government mandated, right? And in fact, that's protected by the First Amendment and like encouraged by the First Amendment.
No,
so like
it would be. It's immune. So how would this work? It's not unlike the DMCA, right? The immunity is conditional, and that is only the sort of thing that is set out by a public law. Otherwise, there's no encouragement or nudging to do any sort of moderation. And that wouldn't exist but for something like a conditional immunity.
So it's not quite like the DMCA in the sense that I think journalists have the obligation ex ante, right? It's not upon receiving notification.
Right.
So
no, it's not the same as the DMCA.
Well, but I think it's actually a significant. It's a significant difference that might be a friendly amendment to what you're saying, because you can't really do it ex ante at scale, but maybe some system where within reason, when you get notification, if there are really, obvious cases, however we define them to be, where any reasonable person would take this stuff down and recognize its harmfulness. Maybe, that might be kind of a middle ground between these two positions.
Yeah.
I had a question about the right of publicity. Oh, I'm sorry. Yeah.
Sure. So I have a question that maybe broadens the scope of what we think of as deepfakes and then complicates that. So just by way of context, I work on deepfakes and what's called synthetic media and human rights in journalism. And the things that have come up in the sort of threat modeling workshops we've done with people have been about the more subtle modifications to images that are not face swaps. So how do we deal with absence of elements? How do we deal with more additions of elements? How do we deal with someone being made to look like they're drunk by a hate modification? And I think this goes to both ends of the spectrum, the journalistic side, because what journalists fear most is you only need to lose your credibility once, and you fool, and that's easier with a small thing than a big thing. And it goes to the content moderation side, because how do you handle that? That's not nearly as obvious as impersonation. So I would love some perspectives on what we should do about that broader range beyond the face swap, the very visible AI-based manipulation, to the far greater range that's more likely to be productized as well by big companies and consumer products.
That that a me question?
I mean, it's,
Yeah,
yeah,
that
it's
is
a
a
hard
really-
question. I feel like some of the first panel talked a little bit about the hard cases, right? Which is what I hear you asking about. I'm not sure I'm equipped to sort it out.
I think that there's, I mean, again, I think this gets into the thing is the reason, I mean, it's a great question. I guess it's just kind of outside of the scope to a certain extent of like the deepfakes. I think because what we said before is just this idea that it's video, and so it transforms these kind of things and brings up all of these new things. But like you're kind of just speaking to maybe things that are like, I mean, we just saw this with you don't need deepfakes, and this is I think when. In the false tweet that Thomas said, but the reason that I made that argument a year ago was that I was kind of like, well, it's nothing, deepfakes will not be anything new because we can just edit video now. Like, I mean, or you can just take we saw this with the Covington boys story, which was that like, you don't even need fancy technology. You could just take a clip of something and misrepresent something. Or you can add a couple of clips, or it can be from an unflattering angle, or there can be any type of things you can do. And you're talking about that, but you're talking about removing or adding things in Photoshop and stuff, and that's been problematic for years. And Photoshop and all of these video and text or photo editing technologies are incredibly pervasive now, much more so than deepfakes technology so far right now. And so, yeah, these all are getting to kind of I think, which is kind of the core of the problem, which is that we can't verify these things, that they're unverifiable, and especially at large scale, and that like the harm is so great, as you said, a source gets ruined because someone sends a fake letter or something else. But I mean, you could always have typed a fake letter or something, or a fake email and sent it. There's various types of, what do we do about lies? I don't know, this suddenly just got very, like I mean, I don't know. I think that's kind of what you're asking.
I have one response to the idea of sort of subtler image manipulations, or just the idea of manipulating images in general, and that is a current quirk of the right of publicity doctrine as it stands in a lot of jurisdictions, is that you have greater First Amendment rights if you transform something in a way, and this kind of harkens back to certain like copyright principles. I've argued against this in the past. I don't think that you should have greater or lesser First Amendment rights based on whether you are transforming an image or not, because it harms realistic portrayals, which I think are entitled to equal sort of First Amendment protection. I've been going at that from a we need greater First Amendment rights perspective, but it's interesting to think about in the context of deepfakes, where actually, you might have more of a right to subtly change an image than to do something that is really realistic. And so for me at least, that's a further reason to not make First Amendment distinctions based on something being more or less realistic. I think you should just recognize it all the same and then think about ways in which you might be able to regulate it regardless of how transformative it is or not.
Thomas, just as a follow-up to that and to your talk generally, why is the right of publicity, as I perceive it, is much more focused on sort of preventing exploitation rather than preventing harm. And why is false light invasion of privacy not a better direction to go in, sort of, dignitary concerns that sound more in sort of harm to individual as opposed to exploiting the individual's image for commercial purposes?
Yeah, so I think that false light could be a powerful tool in the arsenal of sort of tort law in this area, but it kind of goes back to my point about what happens if you have the disclaimer. So I think the false light claim goes away as soon as you have some sort of disclaimer that says, hey everybody, this is fake, because you're not actually doing anything that's sort of putting somebody in a false light, because everybody knows that it's not real. In the same way that I think you could probably defeat a lot of sort of defamation type claims by disclosing that what you are doing is a fake. The reason why I think the right of publicity might still have something to do here, in part relates back to kind of Jennifer's work on this, which is, yes, we have come to think of the right of publicity as being something that is about property type harms, or that, you know, it is about an economic interest that you have. But that loses sight of the sort of the roots of the talk, which sound in misappropriation, very sort of emotional type harms that you can have. I'm not ready to let go of that part of what writer publicity can do. I think it creates all sorts of really tough problems from a First Amendment perspective for some of the reasons I talked about. As soon as you start talking about emotional or dignitary injuries, then the First Amendment starts to get a little squeamish about that. But I think that we should face that head on and come up with a doctrine that allows you to do that, rather than sort of saying it's just about property and just about economic interests.
There's some interesting tension, I think, in some of the comments that are going back and forth, and I think this relates to all of your presentations to some degree, but the sense of, okay, the deepfake problem is new, and we should let some norms settle, right? And also, it's not new, because we've seen different versions of this, and the whole idea of falsification and propaganda and all that, that's been around forever. And that makes me wonder if part of what's so interesting about your discussion is what's the role of law in all of this? If we still believe, maybe naively, that the law has something like an educative function, that the law is supposed to shape us, and the law is part of how we become the society that we are, isn't it already way too late, right? That, in other words, we got here because the law has had no real substantive commitment to attacking falsity. So that actually it's not a question of is it too early, it's way too late, and maybe it's completely hopeless. And the concern that I have too is that there is a sense in which, as on a personal level and a social level, right? And so this relates, I think, to the Section 230 question. If we want to look at experiments of, here's this new thing or new technology, let's give it all of the room that it needs and not have law get in the way. Well, haven't we seen exactly how that's played out, right? That there's this idea that, you know, are these companies going to regulate themselves? Are they going to do right by us? Well, of course not, right? So we know exactly what happens when law decides to back off. So law backing off is not, you know, not a choice. It's definitely a choice. And what concerns me a lot as we talk even more about how, well, look, the deepfake problem really goes back hundreds and hundreds of years to things like, you know, blood libel and what have you. It really does. And I think we've never really grappled with that. And what's really troubling is all the research that shows that we've got this kind of hedonic adaptation, right? So things get worse. So when you said that about fake news, everybody talked about it and now we're not, that worries me because we get upset about it and then we get used to it, right? So as Tobias Wolff says, it's awful what we get used to. So what I'm worried about is every time law steps back, we keep moving our own goalposts and we don't even know what shocks us anymore. So I'm really concerned that if we are going to be looking for the law to do something, it's from the perspective of saying law has not intervened in the way that it should have, and we really need to make up for lost time.
I'm convinced. No, like I'm serious. Well, I mean, my response to that would just be, I mean, I think that I think that is the very good counter argument to, like, you know, that I have with what you just said is basically the struggle. But what I presented and then what you said are kind of the struggle that goes on really internally with all the time. Like, I'm kind of always thinking about that. But there's one of the things that I would say is, like, I think we spend, and I really don't want to, like, kind of be a Pollyanna or tech utopian about this, but I really do think that, like, we discount how much better some of a lot of this technology that has has grown has made us. And you said that, like, these companies have not represented or don't care about our interests, but I think that, like, there are a lot of companies that do care about our interests and provide us with free services that we all use and that we take advantage of and have made our lives richer and better and allow us to communicate and connect with our friends or have more free time or whatever else. And I think that I think that that's something that can't be kind of forgotten, even though there are a lot of privacy concerns and all kinds of other harms that are wrapped up in this new world, that those are things that have happened too. So, I mean, but I think that your point to things normalizing is absolutely 100%. I think that that's the real damage, or the like literally normalizing that word is about norms setting in and becoming, you know, things becoming like de rigueur. Like, there's kind of a the fear. I think that might actually be what happened with fake news. Is that it's just ubiquitous now, and that, like, we just take it, we either we're more aware of it, but we also just don't care about it as much, and that people become kind of lazy. But yeah.
Meredith, can I see you're standing, and we have to end, right? I want to say something real quickly. So, I mean, there may be tension or disagreement on the panel on a couple of things. I mean, but I think we do have some agreements. I do want to say, though, that I don't think we should take as given that the platforms and the internet themselves are pure expressive spaces. My view is that they're purely commercial spaces, and all the questions that came up in the last discussion, apply with as much force, and on that point. But I also want to say that law has always been on the ready for when there are misrepresentations. The defamation claim is clearly one example. And I want to say on the point that on the question of how defamation interacts with journalism norms, as a matter of law, as a matter of course, as I understand it, you couldn't allege maliciousness because malice. You couldn't allege malice just because someone didn't abide by a convention in journalism. But it was a factor to consider. And we have, since 1996, removed that mechanism under law. So Marianne, you say maybe too late, and it may be, but the law has always been ready to maybe ineffectively, but has always been ready to deal with this. For some reason, we've accepted one single industry from it.